And that's what's happened today in Seattle. So the first legal challenge to Donald Trump's attempts to end birthright citizenship. The judge who sat on this case, brought by 4 states, said it was a blatant, flagrant breach of the Constitution.
In another shocking attempt, Trump has attempted to end birthright citizenship. But what does it mean for the future generations of Americans? At the heart of this discussion is an executive order, officially designated as Executive Order 14,156, protecting the meaning and value of American citizenship. This order issued on the first day of the current administration, so what does it aim for? Let's find out. Specifically, it sought to end the practice of granting automatic citizenship to babies born within the U.S. to parents who are undocumented immigrants or those holding temporary status. This move represented a significant departure from over a century of legal interpretation and practice. For more than 125 years, the prevailing understanding of the 14th Amendment to the U.S. Constitution has been that virtually all individuals born within the nation's borders are citizens, regardless of their parents' immigration status. This principle of unrestricted birthplace-based citizenship has been a cornerstone of American law.
And to end birthright citizenship to the Supreme Court, basing his argument off of a fringe legal theory that lower courts flat out reject. I want to get to NBC's Lawrence Hurley. Lawrence, this could be a very big deal if the Supreme Court decides to take it up, and if they rule in the Trump administration's favor, it would completely change the way that citizenship works, birthright citizenship works in this country. But those are 2 big ifs. Fair?
Yeah, I mean, it's long been understood pretty much ever since the 14th Amendment of the Constitution was adopted that, anyone who's born in the U.S., basically, with a few tiny exceptions, are U.S. citizens. But the Trump administration kind of wants to drive a truck through that exception and say, actually, birthright citizenship doesn't apply to the children of people in the U.S. who don't have legal status.
The executive order, however, faced immediate and forceful legal opposition. Multiple lawsuits were filed swiftly by various parties, including several states, organizations advocating for immigrant rights, and expecting mothers who would be directly affected by the proposed change. Within days of its issuance, the order encountered its first legal setback. On January 23rd, a federal district court judge in Washington state, John C. Coffenor, delivered a strong rebuke, labeling the executive order as blatantly unconstitutional. Judge Coffenor issued a temporary restraining order, effectively preventing the implementation of the policy for an initial period of 14 days. This legal challenge was further solidified on February 5th when another federal district judge, Deborah L. Boardman, issued a preliminary injunction. This injunction goes beyond a temporary halt, as it prevents the executive order from being put into effect while the legal challenges continue to be heard in the courts. A preliminary injunction is a more significant step, indicating that the court believes the plaintiffs have a strong likelihood of success in their legal arguments. As a consequence of this preliminary injunction, the executive order remains blocked indefinitely. Its implementation is on hold until the various legal cases brought against it are fully adjudicated and a final judgment is reached by the courts. This means that the current understanding and practice of birthright citizenship in the United States remain unchanged for the time being.
My policy will choke off a major incentive for continued illegal immigration, deter more migrants from coming, and encourage many of the aliens Joe Biden has unlawfully let into our country to go back to their home countries. They must go back.
The concept of who becomes a United States citizen by birth is a deeply rooted principle, tracing its foundation back to the aftermath of the Civil War and the ratification of the 14th Amendment to the Constitution. This amendment was a direct response to the Supreme Court's infamous 1857 Dred Scott v. Sandford decision, which declared that African Americans were not and could not be citizens, a ruling steeped in the discriminatory ideologies of the time. The very first sentence of the 14th Amendment unequivocally states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." While the promise of this amendment faced significant hurdles and the rise of Jim Crow laws, its core aim was to dismantle the notion of a class of people living under American law but denied fundamental American legal rights. Establishing citizenship based on birthplace was a deliberate move to ensure that individuals born within the nation's borders would be recognized as citizens irrespective of their race, with only very specific exceptions. Historically, the children of individuals who are not legally documented have been understood to be protected under this very clause of the 14th Amendment.
About some of your other promises on this topic. You've promised to end birthright citizenship on day one. Is that still your plan?
Yeah, absolutely.
The 14th Amendment, though, says that, quote, all persons born in the United States are citizens. Can you get around the 14th Amendment with an executive action?
We're going to have to get a change. We'll maybe have to go back to the people, but we have to end it. We're the only country that has it.
Through an executive action?
We're the only country that has it. Do you know, if somebody sets a foot, just a foot, 1 foot, you don't need to, on our land.
Legal scholars largely agree that undocumented immigrants come to the United States for various reasons, including seeking employment, contributing to the economy, and becoming part of American society. The basis for enforcing immigration laws against them lies in the fact that they are subject to the jurisdiction of the United States. Over the years, the 14th Amendment's Citizenship Clause has been central to significant Supreme Court decisions addressing birthright citizenship, particularly due to some initial ambiguity surrounding the phrase, subject to the jurisdiction. A pivotal moment in clarifying this ambiguity came with the 1898 Supreme Court case of United States versus Wong Kim Ark. This case directly addressed whether a child born on U.S. soil to Chinese immigrants, who at the time were barred from becoming citizens under the Chinese Exclusion Acts, was entitled to birthright citizenship. The Supreme Court's ruling in Wong Kim Ark firmly established the precedent that virtually anyone born within the United States is a citizen at birth, regardless of their parents' immigration status. This decision has stood as a cornerstone of American citizenship law for over a century. However, this long-standing precedent faced a significant challenge with the issuance of Executive Order 14,156, titled Protecting the Meaning and Value of American Citizenship. This executive order, enacted by President Trump, proposed a radical departure from the United States' well-established policy of unrestricted birthplace-based citizenship. While the order acknowledged that the 14th Amendment rightfully repudiated the Dred Scott decision, it asserted a different interpretation of the Citizenship Clause, arguing that the 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. Based on this interpretation, the executive order outlined two specific categories of individuals born in the United States whom the administration believed should not automatically be considered U.S. citizens at birth. These categories included a child born to an undocumented mother and a father who is not a citizen or lawful permanent resident, as well as a child born to a mother who is a temporary visitor, and a father who also is not a citizen or lawful permanent resident. In essence, the order sought to introduce ancestry as a determining factor for citizenship, requiring children born on U.S. soil to have at least one parent who is a U.S. citizen or holds a green card to be automatically recognized as a U.S. citizen at birth. The executive order further directed government agencies within the United States to cease issuing documents that recognize babies falling within these newly defined categories as U.S. citizens. One potential and significant consequence of this directive would have been the U.S. State Department being prohibited from issuing U.S. passports to these children. Moreover, the directive could have prevented the federal government from recognizing birth certificates issued by state and local authorities that identified children targeted by the executive order as U.S. citizens, potentially creating significant confusion and legal challenges at the state level. The announcement of this executive order triggered immediate and substantial legal opposition. Within a short period, 6 lawsuits were filed by a coalition of 22 states, various immigrant rights organizations, and expecting mothers directly affected by the proposed changes. The core argument presented in these lawsuits is that the Citizenship Clause of the 14th Amendment unequivocally guarantees unrestricted birthplace-based citizenship to all individuals born within the territory of the United States. The legal challenges emphasized that in overturning the Dred Scott decision, Congress explicitly rejected any notion of birthright citizenship being determined by race, heredity, or a parent's immigration status. Furthermore, the Supreme Court's ruling in the Wong Kim Ark case was cited as a definitive legal precedent solidifying this understanding. Consequently, the lawsuits argued that the executive branch lacks the constitutional authority to unilaterally rewrite or nullify a constitutional amendment, or to limit who receives United States citizenship at birth based on its own interpretation. In one of the initial legal challenges brought by the states of Washington, Arizona, Illinois, and Oregon, Judge Kavanaugh, a Reagan appointee, issued a temporary restraining order, effectively halting the implementation of the executive order. In his ruling, Judge Kavanaugh described the executive order as blatantly unconstitutional. Following this, on February 5, 2025, Judge Boardman issued a preliminary injunction in a separate lawsuit filed by expecting mothers. In her decision, Judge Boardman repeatedly emphasized the Supreme Court's clear ruling in Wong Kim Ark, stating that it definitively settled the question of birthright citizenship. She further noted the absence of any court in the country ever endorsing the president's interpretation of the 14th Amendment's Citizenship Clause, declaring that her court would not be the first to do so. This preliminary injunction carries more weight than a temporary restraining order, as it indefinitely prevents the executive order from taking effect while the legal proceedings continue. During his presidential campaign, President Trump had stated that the aim of this executive order was to discourage future waves of irregular migration. However, the lawsuits argued that abolishing birthright citizenship would only serve to impose second-class status on a group of children born within the United States. These children, despite being born and raised in the U.S., could face denial of basic health care, the right to vote, the ability to hold certain jobs, and difficulties in obtaining necessary identification. The legal challenges asserted that the executive order would effectively resurrect the notion of a caste-based system, subjecting individuals to discriminatory treatment based solely on their parents' citizenship status. They warned that such a policy would dangerously steer the country back towards the reprehensible conception of hereditary birthright citizenship espoused in Dred Scott. It's clear this issue touches on the very core of what it means to be an American, and don't you think the courts will have a crucial role in deciding its future? Let us know in the comments, and if you want to stay on top of this, smash that like and subscribe button.